case number 118663 in the matter of L.J. Buckner, Jr.
Good morning, Penny Moylan appearing on behalf of the Disciplinary Administrator's Office. Chief Justice Nuss, I would request 3 minutes for rebuttal.
3 minutes is granted.
Thank you. As the court is aware, this is original action and discipline. It's a little bit different in that the Disciplinary Administrator's Office has filed exceptions with the hearing panel's report. Namely, the hearing panel's failure to find that the respondent's conduct violated Kansas Rule of Professional Conduct 8.4c, which is conduct involving dishonesty, fraud, deceit, or misrepresentation. By way of a brief factual summary, the complainants in this case hired Mr. Buckner to defend them in a mortgage foreclosure lawsuit and to also assert several counterclaims against the bank that held their mortgage, and also to assert a motion for punitive damages. In February 2014, Mr. Buckner sent them an engagement letter, and the letter in pertinent part provided that he would charge $300 per hour, that he would cap the client's payments at $500 per month, and it also provided, and this is a quote, "Buckner is entitled to and may recover the full amount of his billed fees from persons other than clients through attorney's fees, provisions, sanctions, or the like." Mr. Buckner forwarded this retainer agreement to the clients in an email. In the email, he told them that they were to pay a $500 per month plus expenses, and he was calling it a monthly cap or fee. He also said, "This will force me to keep track of time in case we are successful in recovering the fees and expenses from persons other than you." The case proceeded, the counterclaims were filed, and the trial was set for the first week in August 2015. I want to fast forward to July 23rd, 2015. It was the final pretrial conference. At that time, the court granted the bank's motion for summary judgment on the mortgage foreclosure. And at that point in time, the bank also asked the court to disallow any motion for punitive damages because no motion had been filed. The court gave Mr. Buckner until the end of the day to file the motion, which he did, and he set it for a hearing for July 29th. On July 29th, the court denied the motion for punitive damages. So at that point in time, the case was going to trial the next week on the counterclaims, which included a Kansas Consumer Protection Act claims. Here's kind of where the crux of the case comes in. On July 30th, the bank, believing this was a good time to push for settlement, forwarded a settlement offer of $25,000 to Mr. Buckner. On July 30th, Mr. Buckner relayed this settlement offer to the clients, and he said, "Under the agreement as it stands, you would have been in your house for 5 years without making a payment, owe nothing to EverBank, and have $25,000 in your pocket if the loss mitigation options were not acceptable to you." The clients rejected this offer, and came back with an offer of $100,000. The bank came back with $49,999, and the clients accepted it. In August, there's evidence that there's emails going back and forth from the clients checking with him about the status of the check. They're getting concerned that they will not have the ability to appeal the mortgage foreclosure if the settlement falls through. On August 20th, the client asked Mr. Buckner for a list of expenses and asked if he can take the August flat fee payment out of the settlement money. On August 21st, Mr. Buckner replied, gave them a list of expenses, and there was a dispute over one of the deposition expenses that he was claiming. On August 29th, Mr. Buckner tells the clients that he has received the check, that he has deposited it, and he will hold it until September 1st, and he has not spent a dime of it.
Let me interrupt you there real quick. I was puzzled how this check got made out just to him and not to the clients and to him.
There was testimony at the hearing that the clients asked Mr. Buckner about that, and he said it was just the standard practice to do that. The bank's attorney also testified that they understood there was no discussion that this was going to Mr. Buckner's attorney's fees. The settlement agreement provides that each party will bear their own attorney's fees. They said they just wrote it out to Buckner Law Firm, LLC, with the understanding he was depositing in his trust account.
That's just contrary to any settlement I ever did in 29 years of practicing law.
That it would typically be in the client's and the attorney's name?
Yeah.
On September 1st, the client sent a calculation also. I'm sorry. On September 1st also, Mr. Buckner dispersed $3,000 to the clients. They were required to move out of the house as part of the settlement agreement, and they need the money for moving expenses. After that $3,000 was dispersed that same day, the client sent an email to Mr. Buckner and said, you know, thank you for the $3,000. They conceded the deposition expense that they were having a dispute over, listed out the expenses, listed out the $3,000, listed out the $500 payment, and said, please remit us the remaining of the settlement of $43,000 and some odd change. For the first time now, the clients hear from Mr. Buckner that there's going to be a problem. When he replies in an email, says, nice try, let's chat. Client immediately emails him back. They have a conference call the next day where Mr. Buckner basically says, I'm going to keep this. I'm entitled to keep it for my attorney's fees. I'll give you $13,000 and some, and I'll keep $30,000 for my attorney's fees. Again, the documentary evidence from there on out shows that the clients dispute that. They said we would have never settled this case if we thought you were keeping it for your attorney's fees. Basically, communication shut down. The clients take various actions. They file a motion to enforce a settlement agreement with the trial court. They serve that upon Mr. Buckner. He does not show up. They send a request with the Kansas City Metropolitan Bar Association Fee Dispute Committee. He does not respond to that. They even contact the mediator. And the KCMBA Fee Dispute Committee is who told them you need to file a complaint with our office, which they did. At the hearing, there are two clear positions taken. The position by our office on behalf of the clients that they settled this case, they believed that they were dismissing their counterclaims, and they were getting the settlement money minus the expenses they owed to Mr. Buckner, plus the $500 payment for August. Mr. Buckner's position at the hearing was, no, pursuant to the language of my engagement fee with them, I was entitled to recoup my attorney's fees from other parties than the clients, and so because my fees exceeded the $49,999, I was entitled to all of it. That was it. There was no other positions taken.
I looked through, spent more time than I wanted to looking through all the file, trying to figure out where the $43,000 is, and the conclusion I came to is that he spent it. Now,
Correct.
Is it sitting, it's not sitting in a bank account?
No, it's not.
Subject to trying to get all this sorted out?
Correct.
Okay.
It's gone. So the panel
So the
found-
bottom line is that his clients got zero actual cash, other
$3,000.
than the $3,000 moving expenses.
Correct. The panel found, well, you know what the panel's violations were. I'm just going to go to basically our argument why there should have the clear and convincing evidence support a finding of an 8.4C. You guys know what the standard review is. You consider the evidence, you consider the findings of the panel, and you consider the arguments of counsel in determining whether there's evidence that causes the fact finder to believe the truth of the facts asserted is highly probable. My brief lays out both the findings by the panel as well as the evidence of record that indicate that Mr. Buckner's conduct here was dishonest. I cite you the case law that says, dishonesty.
I'm sorry to interrupt, because you've got a good stream of thought going. But just for clarification, is the question before us a question of fact or a question of law?
I believe there are sufficient findings of fact made by the hearing panel that support a conclusion of law that Mr. Buckner's conduct.
So you're not
violated
asking
8.4C.
us to overturn a factual finding by the panel. You're suggesting the panel made an error of law in not coming to the appropriate conclusion based on the facts that they did find.
That's correct. I do take some issue with some factual findings regarding aggravation, but I don't even know if that's of any sort of material consequence. But as far as 8.4C, I believe you can look at the undisputed factual findings made by the panel and conclude as a matter of law that 8.4C was violated.
And we don't have to find dishonesty, because 8.4C involves other misrepresentation,
Fraud,
deceit, fraud,
misrepresentation.
that sort of thing. Is dishonesty a lower standard than those others? Is that the lowest in that list in 8.4C?
In my opinion is, based upon the decision from another jurisdiction defining under the rule, plus this court on another case. I mean, dishonesty basically can show a lack of straightforwardness. And I say in the brief, even if you give Mr. Buckner the benefit of the doubt and say he truly believed that he was entitled to this and did nothing to lead his clients to believe they were going to get that money, that you see the findings made by the panel that fee agreement was misleading and confusing. You see his conduct where he tells them you'll have $25,000 in your pocket. And then at the hearing, when I asked him to explain what he meant by that, he said, well, because they were the ones with the claim against the bank. And so they were entitled to get it from third parties, and then I was entitled to get it from them. But then yet his testimony throughout the hearing was, it came from third parties, so I was entitled to get it from the third party. So to answer your question, Justice Johnson, I do think dishonesty is probably broader than fraud, deceit, or misrepresentation.
Do we look just at his conduct with respect to his clients or subsequent to the complaint? And the reason I'm asking that is the panel called his reconstructing time records 2 years after the fact to be inaccurate, unfair, and deceptive practice.
I think they're all bundled together because I agree that the panels...
If they're bundled together, you're saying that when the panel makes that finding that he engaged in inaccurate, unfair, and deceptive practice, that would be a violation of 8.4C.
Yes.
Okay.
I think, again, that goes towards his whole position taken about his entitlement to this. And as the panel correctly noted, if he truly and his clients understood that he was getting the settlement amount because of the attorney's fees, they didn't even know what his attorney's fees were. I mean, they weren't created until after the fact, these invoices. The other thing, too, that I think is telling that was a finding by the panel was that when Mr. Buckner was asked to explain, well, why in the world would your clients reject $25,000 if none of it was going to them? And his response was basically they were negotiating a higher attorney fee for him. The panel found that this is troubling because it is inconsistent with other probative evidence. Again, I think that supports a legal conclusion that his conduct in here was dishonest. I know that each case is adjudged on its own facts, but this court's case law is clear. When an attorney engages in dishonest conduct toward a client, converts their money, disbarment is really the only appropriate sanction.
But we don't have to find dishonesty, and we don't have to find intentional rather than knowing in order to disbar, do we?
That is true. In fact, I think N. Ray Quinn talks about that issue, that intent is not, you don't have to establish intent. I believe it talks about that in the notes under 8.4C, that intent is not a requisite element of finding dishonest, fraud, or misrepresentation under 8.4C. So we just asked the court to determine that the clear and convincing evidence of record as found in the panel hearings findings of fact supports a violation of 8.4C and impose a sanction of disbarment.
Do we have any further questions? Thank you, counsel.
May it please the court, members of the court, Mr. Chief Justice, John Ambrosio on behalf of the respondent.
Counselor, before you start, I want to clarify there was a negotiation. $25,000 was offered by the bank.
Correct.
Counter offer of $100,000. Bank came back with $49,900. His clients came back with $75,000. Bank says no, $49,900 the max. And you're saying that all of that negotiation on behalf of his clients was so that we could put more money in his pocket?
Correct. As ludicrous as that may sound, that's exactly what I'm saying.
Then,
and that's what the
if
panel
that's,
felt.
Just a second. If that's the case, then why would he tell them that on August 26th, once I get the check, I'll deposit it and disperse the funds when they're available. 3 days later, he says, a check came Thursday, deposited the same, bank says hold, release September 1. If so, you'll get paid the same day. I have not spent a dime of it.
Inartful communication. Inartful
Or
communication.
incredibility.
Huh?
Or incredibility.
I stick with inartful, but I hear what you're saying. Let me be clear that we accept the recommendations and the findings of the panel in this case. He understands, he meaning my client understands, and we all understand, when you have a 207 violation and you don't answer the request of the disciplinary administrator's office and you don't file an answer, that you're going to get suspended. He understands that. He also understands he should have had a trust account. He also understands that when there is a disagreement over a fee, and this is regardless of the type of case it is, whether it's a disciplinary case, a criminal case, a PI case, the obligation of the lawyer is to put that entire amount of money in a trust account that bears interest until it is decided by a court or some other body as to how that fee should be distributed. He didn't do that, and he understands why he's in trouble because of that.
Even though he said, to these people, I don't count my chickens before they're hatched. And he spent the $43,000 even though it was in dispute.
Correct.
That seems pretty obviously deceptive.
Or he had the meltdown that he talked about, or he was confused, or he didn't have any idea what he was doing.
Does he have the $43,000 now to pay these people?
Does he have that 43? No, that money was spent.
understand
You're
that.
asking if he can make restitution?
Yes.
And I don't know the answer to that. I don't know the answer to that. And I think there's a claim before the protection fund for that amount. I may be incorrect about that.
Are you? You said just a minute ago that he didn't know what he was doing. Are you
He had a
suggesting
meltdown.
that you can achieve a certain level of incompetence that absolves you of dishonesty?
I think you can achieve a certain amount of agita, as we say in my background, or anxiety that causes you to make big mistakes that can be interpreted as dishonesty. But Mr. Justice, that's not what the panel said. They said he made some mistakes. They said he was inartful, and they said that the facts did not show that he was that dishonest or he was not involved in fraud. You don't have to accept it.
Do you think this is do you think
Factual.
that finding is a fact finding, or are we talking about
Factual.
legal determination?
I think it's all factual. I think it's all factual, and how they, not you, interpret the facts. And they were there. They heard the witnesses. They watched the witnesses. They heard the other two people who were obviously difficult to deal with, and they heard my client testify. He was a lawyer for 24 years with a Yale background, never had a problem with disability, never had a problem with discipline before. He came back from back east to be out here because his family was here. He was in a large law firm, left that law firm to go out on his own. And he made some mistakes. He did a tremendous amount of work for these people. And I understand what we all have been taught to do is you keep track of every second that you pay on every case, which is what I was taught and what most lawyers were taught. Even in personal injury, you should do that. In this case, he should have kept contemporaneous time records. He put those records together at the end to answer the entreaties of the disciplinary administrator's office. Now, what he could have said was, if he was really dishonest, here are the records, and I did them contemporaneously. If he was going to lie, if he was going to cheat, that's what he said. He said, I put them together after the fact. If I was going to lie, I would have said, I did them at the time. Prove me wrong. He chose not to do that. Couldn't tell if there was a question there or not.
Well, I thought I saw someplace that he testified that when he got the funds, he put it in his trust account.
He didn't have a trust account. He had
Well, I
closed
know he didn't, but he didn't testify
I don't
that.
remember him testifying anything about a trust account. He had closed his trust account earlier, is my understanding, and then he put in his operating account. Which
Now,
I
my
understand is
question
wrong.
there is, how can that not be intentional conduct when you take money from a settlement and you put it with your money? Why is that commingling not an intentional act? Because you're the
I hear what you're saying.
definition of intent from the annotated treatise on standard for imposing lawyer sanctions says, quote, the conscious objective or purpose to accomplish a particular result, end quote. He takes a check, goes to the bank, says, put it in my account with my money. And why isn't that intentional conduct?
I think it was negligent. I'm not saying he was right, Mr. Justice. I'm not saying he was right. I'm not saying a good lawyer would have done that.
No, I'm just saying,
he made a
why
mistake.
wasn't that an intentional act?
I don't
It
see
wasn't
how
a
it was
mistake.
intentional.
I mean, the bank didn't put it in.
No. It was intentional. He said put in that account, and that was wrong. Obviously, that was wrong. Obviously. I mean, the problem here is, and I'm fighting because that's what I've been taught to do, is I fight about everything, because that's my job as an advocate. The problem is he did some things wrong, but the panel bought my argument. The panel bought my client's testimony. The panel bought what he said, and they didn't think he did anything that was a disbarment offense. And I think that's important. I think that's absolutely important. The panel said he needs to be suspended for all of his actions, but for only the 2 years. Now, I will tell you, he's never going to come back to practice law. His meltdown led him to say, even with the Yale Law degree, even with all of this practice experience, I'm quitting. And what happened after that meltdown? He worked in a warehouse, in a blue-collar job, not that I'm denigrating anybody who does a blue-collar job, in order to pick up his psyche to the point where he was able to close out the cases he had. Now he works in a position with a publishing company that is not, he doesn't have to be a lawyer for, it's almost a clerk position in order to feed his family, because he doesn't want to practice law again. I don't think he'll ever come back again. I'm asking you to follow the recommendation of the panel. And that deals with the 207 violation, and that deals with the other violation, the commingling and everything else. If there are no more questions or arguments with me, my client would like to address the court.
Very well.
Thank you. You be calm. Don't do what I did. Okay.
May it please the court, I'm LJ Buckner. It's really hard to sit here and have my conduct talked about in this way. I can tell you I've worked really hard to do right and to bring honor on myself, my family, and the profession. I apologize to the extent that I have not done so for myself, my family, or our profession. My wish is that, and I know that you will read the record carefully, and with that, I respect your judgment.
Mr. Ambrosio represented that you do not intend to practice law anymore. Is that what you're thinking, or tell us about that?
You know, where I'm at now, that even possibility is far off. You know, we're here asking to support the panel's recommendation of 2 years. You know, I'm in a job that I could work for the rest of my life, and that's my plan. I don't intend to practice law. So.
Do we have any more questions of either counsel? All right, thank you both. You reserve 3 minutes for rebuttal.
I'll make it brief. I want to address two things that Mr. Ambrosio said. First of all, he said the panel believed his client. I think, as is clear, and if you look at the hearing panel's report, they did not believe the respondent in this case. They lay out under paragraph 51 all the reasons why they don't believe the respondent in this case. Why his position that he was entitled to keep all of that was not consistent with what he told the clients, was not consistent with what he testified to at the hearing. And then just the last thing I want to do, Mr. Ambrosio in his brief and up here before the court today wanted to characterize Mr. Buckner's failure to place the money in a trust account, keep it in a trust account, basically was caused by a complete breakdown. If you look at the exhibits submitted by Mr. Buckner, specifically it's in volume 3 or 4 of the record, Exhibit A, it's the letter from Mr. Buckner's psychologist that treated him. And she basically said that his issues in this case are characterological. It's a hard word to say. They weren't created by depression. They're created by some disdain for others, ambition, need for recognition, a sense of self-centered importance, narcissism. So I would just argue that there was really no credible evidence supported that his meltdown was the cause of him not doing what he's supposed to do under the rules of professional conduct. I think the evidence in this case clearly demonstrated that he had a difficult case on his hand. He probably had some difficult clients as well. He led those clients to believe that they were settling the case, they would receive those funds. Then once he had the check in hand and started thinking about all the work he put into it, he decided, I'm going to keep some of this money. I suggest that there are enough findings by the hearing panel report to find a violation of 8.4C, whether it's dishonesty, fraud, misrepresentation, and that warrants the sanction of disbarment.
Any more questions? See none. Thank you, counsel. I thank all of you for your arguments this morning. Clerk will take this matter under advisement. That concludes this morning's docket. Court is now in recess until 9 o'clock tomorrow morning.